Welcome to our second episode of Level Table Live. Talking today about forget AI, get to know other powerful review and analytics tools that you're not using. I'm joined by Daniel Bonner, our Director of Client Solutions at Level Legal. And this, again, is our second time to join you and for you to join us in Level Table Live. How you doing, Daniel?
I'm good. Excited about this.
Yep, I am too. We've got a guest today. The guest is Vinny Liu, who is a Senior Project Manager at Level Legal. And again, we're going to talk about powerful review analytics tools, maybe that people are not using, maybe they are using, but that's what we're going to talk about today. Before we get any further, I want to make sure that we keep this in mind. This is being recorded. And so those of you who are joining us, please keep that in mind also. If you have a question that you'd like to pose for Vinny, our expert, or Daniel, our expert, then make sure and send it to us, and we'll get to it, and that'll help our conversation. Vinny, hello.
Hello.
I'm glad you could join us.
Likewise.
So why are you here? Tell us about you and how you got here, and a little of your background.
Yeah, sure, absolutely. It's an interesting story. I think a lot of people in this industry fell into this industry, and I was very much that case. Back in 2004, in my early 20s, I was sort of doing weird jobs just to pay rent, and I literally, the day before I got this job, I was doing landscaping, and my roommate found this data entry job. And so we get there, and what we were doing was basically looking at scanned images of documents and taking that coding and putting it essentially into a database. I had no idea what it was for, what we were doing. To me, it was kind of just a paycheck. It was later on that I discovered that this was very early on in the EDRM of collecting documents, right? And being able to search on those documents. That's what we were doing. So from that job, I sort of transitioned into project management through various vendors, larger vendors mainly, and did do a quick stint, 3 years of consulting in e-discovery before I made my way back into project management with you guys here at Level Legal. So that's where I am now.
Great.
Vinny's not going to brag about himself, but I will. So I've been on a number of client calls with Vinny. There's nobody better to guide a client along a data-intensive journey. He's a true expert, and it's a privilege to work with you. I'm excited about our talk today.
Yeah, thank you, Vinny. So let's maybe start the conversation with some context, and that is, when we're talking about analytics. I do have a war story to set it up. Let's start with this. So many years ago, when I started practicing law, we documents were documents. They were actually on paper, like we have here, and there were very few, if any, in digital format. So there were bankers' boxes of documents, hundreds, if not thousands, if not hundreds of thousands, that we would review for litigation, for production. I remember 30 plus years ago, I worked on a toxic tort case, and it involved steel workers, and there were magazines and newsletters and documents that steel workers might or might not have read, but they were trying to establish public domain. All that is now digital. Many people practicing still remember those days, many don't. But the thing about it is not really that they're digital or not. As we all know, what happened is once everything became digital, there became many more documents. So there's hardly ever an unrecorded thought now, because we're texting, we're instant messaging, we're emailing. And so the volume of documents grew, and along with that volume of documents came the huge burden that it is to litigants or those in regulatory actions to review and know what is in there. So bit of level setting, to state the obvious for many. But that's why it's important that we use the tools that we have in order to get the data set down to a manageable number. Having said that, Daniel, Vinny, I'm interested in, when we talk about analytics, what do we mean by analytics? What does that term mean?
Yeah, I mean, I'll jump in. So the academic definition of analytics relates to the computational analysis of data and statistics. Specifically in this context, we're looking at patterns, metadata markers, and other document characteristics that we can leverage to accelerate discovery in a matter, whether it's for production purposes, fact development, how to allocate resources, and things like that. Vinny, pile on there, with your experience as well.
Right. Thank you, Vinny. So moving to our first question, I believe we have a question from first question. So here it is at the bottom of the screen. Vinny, Daniel, there are a lot of tools for us to use. But what do you think is the most overlooked document review analytics tool today?
I need to call this.
Yep. Hey, Vinny, we can't hear you, and I'm not sure if anybody else can.
Oh,
so
can you hear me now?
We can hear you now.
There we go.
Please start that answer over.
Sorry about that.
Nope.
So yeah, that's an easy one for
I love
me.
what you said, by the way.
Yeah, that was the most profound thing you've ever said, Vinny. Try again.
Nope. Sorry about that. As a project manager, I see this a lot when talking to clients about this. For me, it's definitely email threading. If you're not familiar with email threading, as an example, let's say you and I, Joey, we have an email conversation. We go back and forth 10 times. Now, if that email conversation is now in litigation and counsel has to review that, what people are typically doing is reviewing all 10 of those emails. So what email threading will do, it will do two key things. One, it will identify where in the thread, the conversation, each email lies, right? So no one will get a number 1 through 10. Number two, the most important piece is which of those emails actually needs to be looked at. So as an example, in that 10th email, that contains the content of the emails 1 through 9. So that way we only need to review the 10th email and not all 10. Now multiply that by however many email conversations there are in your data set. You could be looking at a large reduction of emails. So that I think is something that should be run on every single case and what we do here at Level Legal, but I think a lot of people do not.
So I have a question. I mean, that's a great point. And that is, we've been suggesting and doing email threading for at least a decade. I remember when there was you had to have a separate tool for it. Now it's embedded in the others. But if it's the most overlooked, it's overlooked. Why is it overlooked? Why are people not using this tool that makes things so much more efficient?
Yeah, I mean, I got to clear the air for a second. For practitioners watching this may shock you, but I'm sure you've seen it in practice too. There may be some reluctance from certain clients to leverage this tool. Very often what happens is that litigators fail to negotiate the usage of email threading during the ESI stipulation or e-discovery order process. And it's very difficult later to come back and say, oh, by the way, we forgot, but we want to use these tools. In addition, I don't think a lot of providers are strategic in educating clients on how things work. And so if lures exist to mitigate risk, they may view a newer technology as just that, something risky. It's battle tested, it's proven, it works well. It's not terribly complicated. In fact, we interact with it. Think about logging into Google, Gmail, how they organize those messages.
Yeah.
It's by thread.
Yeah.
It works every time. You can also do a couple of cool things with the threading, even if you don't want to limit your production to the most inclusive terminal thread, the last in time message. If you need to produce each and every email, you can still deploy analytics in email threading context to organize the workflow. You can batch out documents, grouping similar threads together. You can also use it for quality control purposes. There may be a good reason items in the same email conversation are coded or handled differently that may flag an item for follow-up. So a lot of benefit there, definitely overlooked, even as shocking as that is to say. From my perspective, another item that's underutilized, in my opinion, is the metadata that's available to all of us in the project workspaces. So metadata is data about documents.
Yeah.
We're talking about email subject, file size, file path, author, things like that. And even the programs that are used to create these files. Those are powerful tools that you can use to start carving the data sets and hunting for things of interest. We've heard about metadata coming up recently, the Amber Heard Johnny Depp trial. They tried to rely on some evidence. There was some question about the propriety of the photos they presented. These are objective markers that each file transfers that can be relied on and used to accelerate your discovery process. So
yeah,
a lot of power there.
You know, speaking of metadata, when we first got into this business 15 years ago, I had to learn what metadata was. I think it's reached the common consciousness level with everybody having iPhones or phones that take photos, and we know now that it captures the location, the time, unless you've turned off that feature. But even then, there's metadata that is captured whenever you're taking a photograph. So
it's an important point. A cool phrase I heard from an industry colleague is ambient contextual data. It's a mouthful, but what we're talking about here is information that exists out in the ether relating to these documents that you can use to build a story. Think about a matter where somebody's location was important. That's not user-created content that is attached to a GPS tracker, probably on your smartphone. Or think about if you need to look at somebody's work patterns in an employment case. You can look at simple things like first email sent, last email read, open times, and start building stories without ever looking at document content. And litigators' bias is to jump right into the data, start reviewing emails. But there's a lot of things you can do up front to stage the files appropriately, to start prioritization in a smart way, and really grease the wheels towards your goals.
Yeah. Vinny, anything to add on metadata?
Yeah, I actually had something to add about email threading too.
Yeah,
Another
sure.
thing that I find is very helpful is to thread opposing data with your data. That way you know which sets of documents from opposing you don't need to look at because you've already seen it. Quickly eliminate documents because you've already seen it in your own client's data set. As it regards to metadata, we had this example actually just a couple weeks ago where we were doing some data set reduction for a client here, and they had something crazy like 250,000 JPEGs. Spot checking them, I looked at them. They were mostly company logos. Sprinkled in there were actual photos. And kind of, Joey, what you were talking about in terms of the metadata, no metadata was provided, which is a challenge. But what we found was the metadata of pictures was in the text. So you had all that EXIF data in terms of camera model, camera make, shutter speed, location. So I was able to run some key search terms, mainly things like iPhone X, right? Which is what they were using to take these pictures. And I was able to segregate for the client which JPEGs were actual photos that they cared about and which JPEGs were just company logos. So a really good use case of using sort of non-traditional metadata to sort of organize your documents.
Great. Thanks, Vinny. I think we have another question from one of our guests who's joining us today. And here it is. Vinny, from your perspective, which is better, TAR 1.0 or 2.0, and why? This seems like kind of a loaded question, but a good question.
I like it. I know, Rachel. Yes, so it is definitely TAR 2.0, right? I do remember the days of TAR 1.0. For those of you who don't, basically you have a control round, and then you have additional rounds of confirming the computer coding. On the administrative side, you might not have seen this on the client side, but on the administrative side, there's a lot of setup that goes into that. Whereas in TAR 2.0, specifically relativity active learning, it's very easy to set that up and monitor. So for that, I think definitely TAR 2.0.
I'll jump in there and add one comment. Depending on the jurisdiction and the matter at hand, there may be a limitation on which TAR model you can use. So for instance, the Department of Justice model e-discovery orders speak specifically about TAR 1.0 in certain contexts. So if you have a choice, we're going to prioritize efficiency, the best practice, lowest effort, best outcome. However, well-deployed TAR 1.0 can yield the same results, but clients should know there's a bit more iteration and setup time, and the sequencing is really important, as opposed to the active learning that is moving in real time with the progress. You've got to stage your resources appropriately, go through the training rounds, and react to new data sets that are collected and added to the case.
Good. I've got a question. Is there a 3.0?
It's coming.
All right. Do we know anything about it?
Likely large language model based predictive coding, content clustering, and pivoting off of the contextual data that's independent from human judgment the computer picks up.
All right. Another episode. All right. So we have another question. We'll move to that. And that question is, how did e-discovery analytics get to this point where we are?
Oh, that's a good one. You know, moving back to the academic definition of analytics, we're looking at analyzing data and patterns. You think about the federal rules of evidence, and I think they first came out in the Federal Rules of Civil Procedure, the 1930s. This was on no one's radar.
There were 5 of them. I mean, they were very simple.
Some of the amendments to the Federal Rules of Civil Procedure, notably in 2006 and 2015, now start to consider and contemplate the ESI that we all face every day. And what you're seeing is courts and practitioners leaning into the idea of leveraging the analytics features that are out there. Most production requirements include a load file being delivered to your opposing party. That includes metadata. That includes all the file markers that organize families and other key content like that. One of the key reasons why this metadata and analytics practice and focus is so important is that you have the ability as a practitioner to answer key questions and to move large piles of data efficiently without the need to look at each document's content one by one. This helps us organize workflows. This helps us accelerate knowledge transfer. Speed to insight is important. If you take a step back and look 30,000 feet at this problem we're trying to solve, it's all about controlling time and expense. Any e-discovery workflow and the exchange of information during discovery, you know, there's some buzzwords we're thinking about.
Yeah.
Is it reasonable? Is it adequate? Is it proportional? And using these tools that are available and using the data about documents that are at issue in each case is a big part of that.
Good. Thanks for the question. Good question. Our next question that we have from our viewer, what trends are we seeing in data analytics? Vinny, take a crack at that.
Hey, Vinny, with apologies, you may be back on mute.
I'm sorry. So I think one of the challenges is volume, right? Volume of matters have grown exponentially since when I started doing e-discovery. So one thing that is, like Daniel had said, is how do we control cost? So analytics is certainly a key component of that, as well as other things that we do here at Level Legal. What we call DSR, I mentioned it earlier, data set reduction, is basically trying to find anything that is junk or irrelevant. We can do that in mass, utilizing a combination of tools, text searching, metadata analysis, and obviously analytics. Categorization is yet another tool that we are utilizing here on some larger cases. So I think it's the need to control cost, as well as making it efficient and quick.
Another trend I'm seeing relates to the types of files that are created in the new way we work. If you think back to the days where everybody was in an office together, you had traditional word processing files, emails, of course. Now with the distributed workforce and collaboration through video tools, even conducting business from your iPhone, and all of the chat-based data that's available through applications on your smart devices, we're creating new files. Each of those comes with their own metadata, their own challenges in the discovery context. Of note, as we see new data types, we can't always rely on the tool set and the workflow that we have in the past. So there's creativity, there's diligence required. Sometimes it's the first project where a client may interact with a particular data type. And so it's important to be laser focused on the idea that waiting within each data set, there's efficiency to unpack and deliver to the clients. Another thing I see in what I believe is one of the most crucial parts of the litigation lifecycle, it's the ECA process, early case assessment. And during that process, we're looking to get a handle on the contours of the data set. We're looking to extract information that'll help inform search term negotiation and putting guardrails, so to speak, around the discovery request. And I'm noticing counsel getting more and more involved in that process as they learn more about analytics, the powerful tools and insight we can extract using them. It informs better and more equitable discovery such that it's not asymmetrical to the extent you can handle that, and yields better results. I always tell clients, never agree to any search term before we do some testing and validate what's there. I don't care who comes up with the search terms, there's going to be false positives. Also, you need to be thinking about searching both content and metadata, right? Because you might get different results depending on how that's deployed. And so the ECA process, from a trend perspective, it's maturing and it's really helping guide our clients through these document-intensive projects.
You raised a good point there, Daniel, and that is you talked about agreeing to terms. And I think one of the things that can be frustrating for us in our position is when the ESI order is already in place and there are some things that have been done and already agreed to by opposing party and the court that may not be efficient. That could involve search terms, that could involve email threading or other items. What else do you see there?
Well, backing up to my point, never agree to anything before testing. But if you do, you need to find providers that don't look at a data set presented as the starting point for batching and document review workflows. You need to find a team that will dive in and give you some further analysis. There's always content clusters, file types, document characteristic markers you can use to either triage data, exclude data defensively, or prioritize. And to help support that, I've got a ESI negotiation checklist that I raise every time there's a new matter conversation. We talk about things that can impact e-discovery, time, expense, burden, and help our clients walk into those negotiations with purpose and confidence towards the outcomes they need.
Great.
So we've gotten some good traction there, and certainly from an ROI perspective, it pays for itself.
Yeah, great.
Guys,
all right, thank you, Daniel. Vinny, go ahead.
One thing I'm doing right now on a case with search terms is it's exact. I don't know if you know about this, Joey, but these are search terms that have already agreed upon on a matter that we're working on. There's 12 search strings. Each search string, or most of the search strings, consist of 50 or more terms separated by an or. That's one term, right? So we obviously ran that because that's what they're asking for. But what I also did was I split them up into individual terms, and it ended up being one term was bringing back 99% of the documents. So we give our clients a little bit more insight to say, hey, your search terms are not great, right? There's one particular term they're looking for a first name, right? Not a great idea. But we can go back to the client and say, hey, by the way, this is the reason why you have 100,000 documents, not these other terms.
Yeah.
No surprise, Vinny, right? That's an old trick of the trade. You vary a very general term in a longer string, and it hides the ball a bit. So splitting them up's the right thing.
That's good. All right, I think we have another question. Aside from email threading, what are other overlooked analytics tools? Vinny, you want to take a crack at that?
Yeah, sure. So let's first talk about what those tools are. So when we're talking about analytics, specifically in relativity and specifically structured analytics or conceptual analytics, we have email threading. We have near duplicate identification. We have foreign language identification. We have repeated content filters. We have active learning. We have clusters, and we have category. So for me, another big one, I'm not going to go into active learning, but another big one for me is categorization. So we're working on a very, very large second request right now. It's been going on for a few months. They're into depositions right now. The database consists of almost entirely of opposing or third-party productions. We're talking about 6 million documents in here. 2 law firms are involved. So what we did is we set up categorization on all of the documents. I think we just ran it on 5 million documents 2 weeks ago. And what it does is we're able to take the coding that the attorneys have done for both hot and issues. So 2 different categorization sets. And we have really good example documents of what's a hot document and what's one of the 15 issues that we have. So we take the coding from those documents and we apply it to the rest of the population, the 5 million documents. So one, the categorization gives each document what it thinks the issues are, as well as a rank. So what we did was we batched out for review. And keep in mind, they still have to review everything, but they just want to look at the documents that are going to be most important to them. So we batched out all of the 90+% rankings for these issues, and that has really saved them a lot of time. I've gotten a lot of good feedback from the client saying, these are really, really good documents. And I said, they're really good documents because you gave us good example documents. So it's not like magic here, right? You have to do the work to find those documents, and it will in turn find you what you're looking for. So I think it's a very overlooked tool that you can use. Categorization is good too, because unlike active learning where it's a binary choice, right? Typically it's positive, negative, or responsive, not responsive. Categorization offers multiple choice. So you can have multiple issues being categorized for one document.
That's great.
Good question.
You know, you mentioned a number of tools there. Do you have kind of examples for any of the others? There was a lot there.
Yeah, near duplicate identification is an interesting one. This is not conceptual in nature at all. It's purely a comparison of text, and that's it. So certainly good to find different versions of contracts or things like that where you're looking for those differences. I have an interesting story where we used it for something totally not that. I had a client call me one time. She was reviewing 200,000 documents produced to her in PDF form, no metadata, no text. She's doing it manually in Adobe, right? I'm like, what are you doing? So I'm talking to her about this, and she's like, I'm seeing a lot of duplicates, Vinny. So I'm like, all right, well, we can ingest it. Let's ingest it into relativity. I ran near duplicate identification, got almost nothing back. So I'm like, what are you talking about, lady, right? Nothing's duplicative. So I get on the phone with her. I did call her lady. Yep. I can't remember her name now. But so she brought up these examples of documents that were duplicates, and I'm looking at it with her and I'm like, yeah, these look exactly the same. And what we found was that opposing counsel had OCR'd the documents after they put the endorsements on. So the Bates numbers were in the text, and when we ran near duplicate identification, naturally there weren't 100% matches, though they should have been. So we used a combination of repeated content filters, which is basically the ability to find patterned text, right? Typically sort of boilerplate contract language that's at the end, and basically ignore that. So we used regular expressions to find all of the variation of that Bates number and the Bates value to remove that from the duplicate analysis. So we did that, and then we reran it, and it was 70%, over 70% duplicative. I gave my client the spreadsheet, all the statistics, all the numbers, even examples. She was able to go back to the court, and they forced opposing to reproduce those documents with basically 30% of what they had originally given her. So huge win for us, but it was all technology driven.
Yeah, that's
a
great.
good story.
Yeah.
You know, when we talk about deduplication, it's very common in the industry to apply a global filter for duplicate content. That covers email families and loose files looking for one-to-one matches. That's represented by various hash value protocols. Even after you dedupe a data set at the family level, there are still tons of duplicates by hash value that you can pivot off with a basic analytics filter. You can go into relativity and hit tally sum average on the MD5 hash value, and it'll spit out by integer level any high volume repeat documents that survive the global dedupe filter. That's a great way to find extraneous content or content that you could move to the bottom of the list in terms of priority. And that's something we leverage all the time. It's a good example. And some of the questions earlier related to other overlooked analytics tools, I got to tell you, as you start finding key content, whatever the source and however it relates to your claims or defenses, it's important that you start looking at metadata markers, things like the hash value, the author, the time frame those were sent within, email participants, even common phrases that are unique to a particular company's approach to doing business, their communication styles, or the subject matter at hand. You can start extracting these details and putting them back into an analytics filter and really provide a lot of insight and value back to your clients. And that's a big part of the practice of e-discovery. It's staying diligent to look for every opportunity to save time and expense. Because at the end of the day, that's what this whole conversation is about.
Exactly. Good input. I think between the two of you, those are some of the two nerdiest and helpful answers to a question that I've ever heard.
I'll lean into it. I'll lean into it.
That's a compliment. When you were talking about the relativity command, you lost me, but that's a good thing.
Tally sum average. That's it, right,
average. Okay.
That's right.
That's
Tally
good.
sum average is let's talk about that. Tally sum average, right? Tallying on MD5 hash and seeing hundreds of thousands of duplicates of a stupid company logo, right? Very quickly able to identify those for sure.
Yeah, that's great. All right. Do we have another question? There we go. Albert asks, what about data visualization? Do you expect it to be leveraged more in the future? And if so, what are the uses? What uses do you anticipate? Vinny, what do you think?
Take that one. Yeah. So, I love data visualization. It is obviously very easier on the eyes to look at. I'm more of, like you said, Joey, I'm a total nerd. I proudly am a nerd, but I like looking at data, but I understand that people like to see visuals, right? So we have dashboards in our relativity environment that display all of the information that we're talking about here in a visual way, whether it's a bar graph or a chart or something like that. So definitely is going to be leveraged. Those widgets in relativity are dynamic, so you can click on those data points and drill down into them. So what uses of data vision do you anticipate? I think kind of like what Daniel was saying, with large language models being all the rage right now, I think that's going to play a factor into being able to gain an understanding of your data visually and very quickly versus looking at the raw data. It's coming.
Yeah. As we talk about data visualization, I think about companies like applications like Power BI and Tableau. The goal of all of this is to put actionable business intelligence in key decision makers' hands. We're leaning in proudly to the e-discovery nerd moniker here, and I like it. But for those litigators that may not be as close to it as us, what do they have to do? They've got to answer questions. They've got to develop strategy. And these data visualization tools go a long way to provide insight in digestible and transferable forms. We're talking about simple things like pie charts, bar graphs, word clusters, where you can paint a picture that might take a long email to explain and equip somebody to go answer a question or to pivot or to find an area of focus. And these are incredibly powerful. A lot of the e-discovery software companies are pouring resources into this area for obvious reasons, some of the reasons we just spoke. In addition to that, I think from a trend perspective, most of the visualizations historically have been quantitative.
Yeah.
Right. So metrics on characteristics or file content. We're going to start seeing more qualitative visualizations. So topics, clusters, key themes, and take this even further.
We talk about telling a story. The most obvious telling a story is telling a story to the jury or telling the story to the court. But there are other places where you've got to be able to tell the story of the data. You've got to be able to communicate with your client and help the client understand and make an informed decision. Sometimes you're telling a story to opposing counsel to persuade them of a reason to come to an agreement or to something else.
Throw in the word burden and proportionality.
Proportionality. You've got to tell a story to the court, even absent the jury. And so visualizations help to do that in many different contexts. So
Absolutely.
Important.
Absolutely.
You know,
Good question.
Joe, a good tool for data visualization in terms of telling a story specifically is Case Dynamics. It's an application in Relativity. It's free to use. If your vendor doesn't have it, you should ask them about it. It's free to install, free to use. You can build visual timelines, all of that stuff, but that's for another day. But just wanted to throw it out there. There's already a solution for that built into Relativity.
Great. I'm gonna take a little bit of a risk here.
I like this.
There may be, because you see people do it all the time in kind of an interview format. So there may be people who are actually tuning in who don't know what relativity is. We're throwing around that term because we're familiar with it and work with it every single day. But just in case there's a person here, there's somebody tuning in that's like, I don't know what they're talking about. And every answer to a question has relativity in it. What's relativity?
Vinny, kick it off.
All right. Man, I've only been using this tool for, I don't know, 9 years now, well, longer. It is an e-discovery platform that is essentially a database containing your documents. That's what it is at its most basic form, but it also is sort of very geared specifically towards e-discovery and all the processes that you have to go do within e-discovery, even starting from legal hold, processing, hosting, productions, redactions, all of that stuff. So it's a widely used tool in our industry, and it's the main tool that we use here at Level Legal. I don't know
Market
how else
leader.
to. Yeah,
no, that's
definitely
right.
their market leader. Yep.
800-pound gorilla.
Yeah.
However you want to call it.
It's a great tool, and the primary purpose of Relativity is to allow legal teams to collaborate on a central repository in a secure fashion and start reviewing records, making the important decisions in terms of how those files relate to the work on the merits. And it gives practitioners a lot of horsepower, specifically in the relativity analytics context, what we're talking about here, to make smart decisions about workflow design, prioritization, triage, and things like that. There are several modules within Relativity that different practitioners may use more than others. Litigators will interact with the document review interface, looking at content itself. Data analysts might be on the processing side, looking at extracting key content and serving these documents up for presentation in that context. So wonderful tool. And for those that haven't used it, it's a lot of fun when you get in there.
If you haven't, you probably will. All right. Do we have another question?
Ooh,
Chelsea, are legal professionals just anti-technology?
I want to take this to start with.
I think you kind of referred to that earlier when you were talking about challenges maybe of speaking with some customers or clients. So that one's yours.
Earlier I said that lawyers exist to mitigate risk. And when you propose technology solutions on an active matter, some decision makers view that as risk. What I find the industry fails to do very often, it's a broad sweeping statement, is educating clients on what the technology does and how it can help them. If you walk into a conference room with a litigator and say, we're going to deploy TAR 2.0, there's going to be a lot of questions.
In relativity.
The better approach is to outline the problem. And let's just say the problem is we've got 500,000 documents sitting that need to be addressed. We've got to confirm discoverability, identify privilege, and inform you and your team on the merits. And let's say we don't have enough time, or the amount in controversy doesn't support an investment in a linear review. We can start presenting technology-based solutions and educating them on how it works, involve them in the process, show them the output. And here's the key, such that they could go explain it and defend the process as proper, as reasonable, as adequate, and all of these other buzzwords that you need to do as you're practicing e-discovery. I don't think lawyers are anti-technology. The adoption rate is slower in legal for the reasons I stated than in other industries. But a big piece of this is education. And most folks in client-facing roles fail to recognize that there's a journey, there's a path, there's familiarity, maturity, and adoption. But a big piece of that is just educating clients on the fact these are battle-tested, proven tools. They're admissible in every jurisdiction. Yeah. The answer I always get, and I'll pass it to Vinny in a second, well, let's try it on the next one. I'm going to give you a tip. If you're concerned about trying a technology-based workflow on your litigation matter, please try it on your next internal investigation. We're not working towards a production event. You don't have to comply with a discovery order or obligations. You got to answer questions quickly.
Right.
As you start using these tools in that context, showing them how quickly you can get them in front of the facts without reviewing every document, and then explain what steps you took and involve them in the process, they're going to go, all right, I see it.
Yeah.
And then on that next litigation matter, we've got a lot of confidence.
Great suggestion. Less perceived risk.
Yeah, that's what it's all about.
If you're internal rather than something you're going to produce. Vinny, do you have anything to add there?
Man, I've had so many conversations with clients where I'm trying to convince them, right? Upsell. This was back when we used to charge for analytics, trying to upcharge, but or upsell. But one method that I would go about is with the client is Daniel's exactly right. It's education, but it's also being transparent with them to say, okay, hey, you don't want to do email threading on this case. That's fine. Is it okay if we run it in the background? Right? And sort of use that for QC to say, hey, you tag this document as privileged, but also in the same thread later on, it's not privileged. That should totally be privileged, right? So that's one example. Another example is using active learning. So I had a couple cases where I did this where the client actually agreed. They said, okay, run it in the background. We're going to do what we're going to do. And so they said, we're done coding. Great. I took their coding, ran it through active learning and said, find me all documents that you think is relevant that they haven't coded yet, or they coded as not relevant, and say, hey, client, take a look at these documents. And more often than not, they missed something, right? And so they became believers in that technology and started using it on every case. So, and I'll finish with this thing. I think the hesitation is the misconception that you're leaving documents on the table. That's simply not the case, right? We have a case right now where we have to review every single document, but we're utilizing active learning just to get the more important, more relevant documents up front.
Right.
So I think that's a big thing. But being able to provide, tangible results that they can look at is huge in terms of being able to convince them that this works.
So, storytelling, right? So, how do we tell the story for the best use of the technology, and then using it on something that's a little bit lower risk, or at least perceived risk. So in case something goes wrong, or in case, that black box somehow misses something, then we can still recover it. So good suggestion. All right. I think we have one more question.
Drum roll.
Rachel again. Thank you, Rachel, for being an active listener. Thoughts on AI and the role it will play in the future of e-discovery? Who wants to take that?
There's a lot here. It's a great question. So anybody that's interacted with ChatGPT or analog large language model programs can see the power in the computer generated content that's output. As you think about synthesizing evidence and telling stories, these tools will be incredibly helpful in taking large piles of relevant data, finding content clusters, and creating some output. Of course, we talked last time about the need to validate the inputs and the outputs. That's something that's going to accelerate very quickly. In addition, on the review side, as the AI-based tools mature, you're going to start seeing earlier returns on the active learning process. These tools will begin to extract and to cluster content even quicker with less input, and that's going to help accelerate the process. I will say, this is a new frontier, and the next few years will be very dynamic in terms of use cases and how well they work, and then refine best practices. And I'm excited to see it. And we're absolutely committed to playing a key role in this with our clients and never letting the status quo guide us. We want to stay current with technology, and this is a big part of that.
I like it. Vinny?
I think it's definitely going to be a significant factor in the future. I think it's too early right now. I think the main concerns, at least in our industry, is privacy, security, compliance. I'm certainly not putting client data through ChatGPT, though I use ChatGPT every day. I use Bard as well, playing around with different AI engines here. It's too early, I think, for e-discovery, but I still use it in my day-to-day. I helped a client generate different search terms in an internal investigation, a fraud internal investigation. So I was able to come up with search terms. I know you can do it with a thesaurus or a dictionary or what have you, but it was able to do it, within seconds. I use it in my planning in terms of, generating an outline of something or for something I'm going to be training on. Very quickly being able to build something to start from. I think if you start utilizing it to do your job, that's going to fail. It should really be an enhancement.
Yeah. I was listening to a podcast on the way up here, actually, and we were talking about use cases, programs like we're speaking of here. And one of them was to take the horsepower these contain and have it help educate you on how to better tell a story. So think about an IP case where you have to explain to jurors something complicated in the technical space. You can tell ChatGPT, explain this, fill in the blank, highly complex topic to me like I'm a 3-year-old. And it will, and it helps. And it gives things to compare it to and orients the story in that context. I'm not saying jurors are like 3-year-olds. I'm saying you can craft the message your documents contain for your audience. And that's going to be a big part of the adoption, I believe, as well.
That's cool. I think they probably involve juice and a nap at some point in that explanation. All right, I think we have come to the end of our time. So it's been great. Time has flown by. Thank you, Vinny. Thank you, Daniel.
Absolutely. This is fun.
So again, at Level Legal, we like to talk about making legal human. And I think we've talked about the human interaction with the various tools that exist today. Keep an eye out for notice of the next Level Table Live, which will be on August 29th. And the topic is going to be how forensics can help you outsmart intellectual property thieves. It'll be at noon Central on the 29th of August. If you sent questions in and we didn't get to them, we will get back with you with a response from one of our experts here. And again, be on the lookout for invitations for next month. Thank you all for joining. Thank you, Daniel and Vinny, again. It's been a great time here. See you next month.
Thank you. See you, Vinny.
Thank you.